The next case to come before the court this morning is JoAnne Doyle, formerly known as St. Clair versus Jack St. Clair. Good morning. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know. And when you come up to the podium, keep track of the clock, and I will keep you apprised of the passage of time. Also, we're being visually and audibly recorded to be posted online, so please try to remain behind the front podium here as much as possible.
Thank you.
We have read your briefs and we're ready to proceed when you are.
Thank you, Your Honor. I may approach. One of Your Honor's Daniel Gibbons, 0065811. I'm here for appellant JoAnne Doyle.
You're going to retain any time for rebuttal?
I would retain 4 minutes. Thank you. This is a post-divorce decree matter. You've read the brief, so you're aware of what the factual situation is. Basically, we have a second marriage for both of them. They both had adult children. During the course of this marriage, there was a mortgage loan taken out by JoAnne's adult daughter and her husband, the Steimels. And both JoAnne and Jack St. Clair, the appellee, were co-makers on that loan. So the real issue here today is this loan and the status of the loan and what the parties' actual agreement was with regards to that loan. The divorce decree and the separation agreement were fairly extensively negotiated prior to the actual final signed document in 2009. And I believe that there were some modifications afterwards that had nothing to do with the loans. What Mr. St. Clair was doing after the divorce decree stated that he would be responsible for all of the Lorain National Bank loans, one of which was this Steimel loan. There was no exception to that in the decree, and what happened afterwards was that Mr. St. Clair, from time to time, would pay the Steimel mortgage, and then he would deduct that from the monthly spousal support, or I'm not sure if it was a property division, of $1,250 that he was paying to JoAnne Doyle. So,
And that loan was 600 and something, if I'm correct?
I believe so. I cannot recall the exact amount.
I just want to say it significantly reduced the payment your
Yes.
client received.
Yes, yes. So there was correspondence between Mr. Deary, who was representing Ms. Doyle in the divorce, and Mr. Giardini, who was representing Mr. St. Clair. And even back from February of 2010, there was an exchange from Mr. Deary to Mr. Giardini, which stated that Jack would not be able to both pay the loan and then deduct that from his other payment of $1,250 per month that he owed to Ms. Doyle.
I thought I remember reading in somebody's brief that the actual provision in the separation of the decree, probably what the same, was that she was supposed to refinance it, or was she supposed to be the sole? Was she going to change it afterwards so she'd be solely responsible and he was supposed to come off of it?
I believe it was the other way around.
I remember reading at some point, I think within 6 months, she was supposed to.
Refinance?
Did that happen?
I don't believe so, no. But bottom line was the agreement was that Mr. St. Clair was to be taking responsibility for the Steimel loan. And through several correspondences back in 2010, 2011, there were exchanges between counsel that this was not acceptable, that JoAnne was not in agreement that he would be able to make payments on the Steimel loan and then deduct those payments from the monthly amount that he owed her.
But counsel, when she eventually filed that first show cause, she said nothing about this.
She did not. She did not.
How do you think that affects your argument here, if at all?
I don't think it does, quite frankly, because there is no limitation on a show cause. every violation is a new show cause, or is the basis for a new show cause. So there's as opposed to coming in and asking for a motion for relief under 60B, where you have timeframes, there's no time frame under the show cause.
If she was going to be responsible for those payments each month, and she didn't make them, so he deducted it, tell me how that affects her financial situation, or how that affects her.
I'm sorry.
If it got paid anyway, and he paid it instead of it coming out of his spouse's support, how does that affect her?
Well, it would certainly probably protect her credit to some degree, but again, the agreement was that he was going to pay the $1,250 a month, and that was separate from the Steiner loan. He also agreed to take the Steiner loan, along with the other LNB loans, and that was part of the divorce decree. So yeah, there was some protection there with regards to credit, but at the same time, the parties knew when they signed the separation agreement back in '09 that this is what it was. And in fact, in correspondence from Mr. Giardini to Mr. Deary back in, I believe, December of 2011, there was acknowledgement, and Mr. St. Clair even acknowledged this in his motion, that at least as early as 2011, December 2011, he agreed that he believed that there was some sort of mistake, that there was some sort of an error in the separation agreement, that the parties had agreed to something else, even though there is nothing on the record. There was nothing filed with the court saying that there was some other agreement. From 2011 until 2014, after Ms. Doyle filed her motion to show cause, Mr. St. Clair did nothing. He filed no motions, did not ask the court for any kind of relief, any modification. Yeah, I think it's clear from his motion that what he's asking for is for relief from judgment on the basis of mistake. And I think...
You're talking about the first show cause?
I'm sorry, the second show cause.
Okay.
I apologize.
Thank you.
The 2014 show cause, yes. So there was nothing filed by Mr. St. Clair until after that second show cause relating directly to this issue was filed. So the timing was rather interesting.
Was the loan paid off at that time? Thought I read that somewhere in a brief, that sometimes...
I'm not positive. I think by that point the loan may have been paid off or sometime shortly thereafter.
Do you think that timing is interesting?
Possibly.
There's a lot of interesting timing in this
Yes.
case. Some good, some not so good.
The whole case really revolves around time.
Absolutely.
Without question. And the issue here is that Mr. St. Clair is claiming after a show cause motion was filed against him that there was some sort of error. And he knew about this error at least back from 2011. He states that in his motion. I mean, he admits that. You know, our position is that it was actually going back to 2010 he was aware of this. Regardless, it's a mistake. And if it's a mistake, then he's got 1 year to file it from the time it goes to the mistake to the time the mistake happens. Realistically, it should have been from the time that the divorce was finalized in 2009. But at the latest, it should have been a year after 2010 or 2011. So for the court, the trial court found that this was some coercive dealing. I'm not really sure how the court got to that. There was no testimony taken. There were affidavits filed. Mr. St. Clair filed his motion with an affidavit. Prior to the non-evidentiary hearing, we filed a response to that. That was also certified and sworn to by our client. So there was an actual sworn statement from our client that was submitted prior to the hearing. She was quite adamant that this was the first time she ever heard of an alternate agreement, or the first time they'd ever discussed it. The purported agreement that was attached to Mr. St. Clair's motion, I think it was Exhibit A. She specifically, in acknowledging or verifying our brief, our pre-hearing brief, she knew nothing about this. This was the first time she'd seen it. It was not something that they discussed her.
How many times did he actually have to make payments for her?
I want to say there was approximately 13 or 14.
15.
15? Thank you.
Only because it happens to be right here in my notes, not because
Thank
my
you.
memory's that good. Don't worry.
So the reality is that this is something that doesn't fall under B5. B5 is, and I think the case law is very specific on this as well. B5 is used if there is nothing else in 60B that applies. And in this case, clearly, it's a mistake. So it'd be 60B1. That absolutely would apply, and there's a one-year limitation on coming back to the court and asking to modify that, or asking for relief under that. So I think the trial court clearly erred in finding that there was relief available under 60B5. I'm not really sure about the course of conduct. I'm not sure how the court got to that point, but regardless, even if it was, and I'm not saying it is, we disagree with that entirely, that was not the agreement. That's not a basis for the relief. The relief sought was for a mistake. It was not a mutual mistake. If there was a mistake, I don't believe there was a mistake because, as Mr. St. Clair's motion even admitted, he knew back in 2011 that there was something that should have been done. The letter even noted, the letter from Mr. Giardini even noted that if they couldn't come to some resolution, that something would have to be filed with the court. Nothing was ever filed with the court for over 3 years. Just
Peripherally, was spousal support something that was retained for jurisdiction of the trial court?
I don't know. I did not represent during the course of the divorce itself, so I really don't recall, Your Honor. But again, it was a motion to modify support.
Right.
So, even if, regardless, it was a motion for relief from judgment pursuant to a mistake. I think when you look at the pre-trial brief or the pre-hearing brief, it's very clear that, our client did not agree to what Mr. St. Clair asked the court to do. And that was never part of their agreement.
4 minutes.
Thank you. So, just to conclude, I don't believe that 60B5 is the appropriate rule for the trial court to use. There was a specific part of the rule that applied, which was 60B1. It was a mistake. Or I should say Mr. St. Clair was alleging that it was a mistake. We disagree entirely. There was contrary affidavits to Mr. St. Clair's affidavits. They were submitted to the court. Clearly there was a very, very opposite interpretations of what this was about. So, bottom line is that if there had been any relief available to Mr. St. Clair, he should have sought it long before 2014. We don't believe that there was any mistake by either of the parties, quite frankly. We believe at the time it was kind of interesting that we waited to file this in play. Sure, it was fun. But in any event, we would ask that the trial court, their decision be reversed, matter either be sent back to the trial court for further proceedings, or just the motion denied.
We have just under 3 minutes remaining.
Thank you.
Morning, Anthony Giardini. I'm here on behalf of the appellee, Jack St. Clair. I think we have most of the facts right, but there's a couple of things I think I want to clarify for you at the outset. It was not a spousal support payment that Mr. St. Clair owed to his former wife, Ms. Doyle. It was what we call a equalization payment. The property settlement was different. They had both agreed that Mr. St. Clair got $165,000 worth of property, more valuable property than she did, and they agreed that over a period of time he would pay her $1,250 per month until that equalization was achieved. So it wasn't spousal support, Your Honor. With respect to this matter, it's a little bit of an unusual matter. It was a divorce decree. This is not a dissolution. So this wasn't a petition. She sued him for divorce. Then the two of them got together and started working on trying to come to a resolution. Always dangerous when clients try to work on resolutions themselves, but the two of them did. And they were actually quite good at it because they resolved all of this was a fairly large don't want to say the state, it was a fairly large amount of property involved. $3.5 million worth of property was involved, and probably over $1 million in commercial loans was involved. And the two of them typed up their agreement, with the deal that they had made. Unfortunately, they did it outside of the two lawyers, and she's bringing things into Mr. Deary, he's bringing things into me, and unfortunately, this provision about the loan, every single item in the typed up document that the two of them each agreed they came up with on their own in December of 2008. Everything was in the separation agreement that we prepared. Not a judgment entry, but a separate separation agreement. Found its way into that separation agreement, except for one small phrase that said, except for the loan number 34105 of Lorain National Bank. That will be paid by, or not paid by, Ms. Doyle. Her daughter was supposed to pay it. And by the way, had for years paid on this loan. This was not a problem loan. This was her adult daughter and her husband's loan that they always paid on.
Was the first missed payment right after the divorce?
2 weeks. And this is where we say that if there was some question about the agreement between the two of them, let's say her affidavit written 5 years later was accurate, that she had never, maybe they discussed it, but she had never finally agreed on it. That is negated by the fact that 2 weeks after the divorce, while Mr. St. Clair believed that provision was in his separation agreement, and we contend she believed it was in the separation agreement, her adult daughter doesn't make a loan payment.
Had she done that prior to that? Was that the very first time she'd ever missed a payment?
I don't know. That's a good question, Your Honor. I don't know. I don't recall him complaining about her never making a payment or missing a payment. But I do know that 2 weeks later, she misses a payment. Jack gets a call from the bank because he's got the banking relationship with Lorain National Bank. So they're not going to call his former wife. They probably don't even know it's his former wife 2 weeks after the divorce. They call him and say, Jack, this is going to hurt your credit. You need to get this payment made because you're a guarantor on this loan. He gets upset. He tries to call her. He doesn't get a response. He goes down and makes the payment. His first equalization payment of $1,250 was due March 1st. He makes the payment to his former wife now, Ms. Doyle, deducts the $657 and some odd cents that he had paid on her daughter's loan so that both of their credits would be protected, and writes her a note. JoAnne, I had to make her loan payment because she didn't make it. And it's in this note is in the record, Your Honor. Writes her out a note. I had to make the payment. I've deducted it from your $1,250. Please talk to your daughter and make sure she isn't late with these payments in the future. So he writes out a lengthy note to her with her check that has the $657. So they cut it in half. Cut the payment in half. Makes that payment in March of 2009. This is 3 weeks after the divorce decree. So JoAnne Doyle, his former wife, knew 3 weeks later that he believed that this agreement that they had made on their own was in force, that it was a part of the divorce decree. He didn't go read the divorce decree, nor did I. I didn't even know about any of this. I don't think Mr. Deary knew any about it, but Jack and JoAnne did. And he told her why he did. And the record is clear. She never even responded to that. She didn't call him up and say, whoa, 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 that's not the deal, or I didn't agree to that provision, or what are you talking about? Nothing. And 5 more times this happens between February of 2009 and 2011, when she files her first motion to show cause. So there were 5 occasions when her adult daughter missed a payment, where he deducted it. And on the very first deduction, he told her why, and there was never a response. Not a letter from a lawyer, not a letter or note from her to him, nothing at all. He doesn't realize it's not in the divorce decree, that one phrase didn't make it into the divorce decree, neither did I, until 2011, December of 2011, when Attorney Deary says, well, I've looked at this, and it's not in the divorce decree. And it's like, you know what, you're right, it's not there, but it should have been in there. This is 3 years later. Now they're arguing, well, it was a mistake, we're arguing a mistake, and therefore we should have filed the motion. But, Your Honor, we couldn't have filed a motion that we didn't know there was a problem to. And I think this date of April of 2011 that the trial court, that Judge Swensky looked at, I think this was very persuasive to her because, okay, maybe JoAnne didn't want to spend the money to file a show cause motion over $657 3 times. That's $3,000, a lot of money. But she pays the money to file a motion for a show cause in April of 2011. There's 2 or 3 things that Jack hadn't done. There was some, a deed to a property he hadn't quite transferred over to her. Some important stuff. It's another paragraph or it's another sentence in the motion to show cause. And by the way, you're now $3,000 behind on your equalization payments. She knew, she can't argue she didn't know she wasn't getting the payment, and she knew why she wasn't getting the payment. He wasn't crying poor, he was crying, this is our deal. And she never responded to it. So he has every reason to believe at that point in time, and no reason to believe that he needs to do anything to the decree, and neither do I, until that show cause motion was resolved, and then we had this correspondence, and then even then we didn't think it was a problem, because after I explained to JoAnne's attorney, this was their deal, and if I goofed up, or if you goofed up, Jim, and not getting it into it, that's on us, but this is their deal. And by now, 14 times, or 15 times, it has happened by the time she does file a motion in April of 2014. Well, why not file it in 2011? Why not file it in 2012, 2013? They're saying we didn't file our motion. We didn't see any need to because she never, ever indicated that she planned on enforcing what she is now claiming was the real deal, or what I say was something that she understood was the deal and then changed her mind after I think the loan did get paid off, Your Honor, sometime in 14 or 15, and by now it's 14 payments at $657 a payment, which is, you know, it's not all the money in the world, but it's a substantial amount of money. And in any event, I think what we're really talking about is the contract. And the case law, and this is pretty clear, the standard is abuse of discretion. And this is, since this wasn't a dissolution, this is the judge's divorce decree that we're talking about, incorporating a contract that we say mistakenly missed out on a provision. That when you consider all the things that they were dividing up, it was a pretty easy one to miss. Because it really wasn't their loan, it was her adult daughter's loan. That had never been a problem. It was just kind of like one of these deals, well, you know, just in case she doesn't make the payment, and lo and behold, 2 weeks after the divorce, she does make the payment. This was not something that was at the top of everybody's mind, because it was one of many loans that he had, that in this case they had guaranteed, JoAnne and Jack had guaranteed. I might add, they also guaranteed a loan for one of his adult sons, but his adult son always paid it, and if he hadn't, then Jack would have been responsible for making the payment.
Counsel, do you know whether the language that said that JoAnne would take over that loan, 6 months comes to mind to me.
You're 100% right.
Did that make it into the agreement?
It did not,
Okay.
Your Honor. It was all part of the one phrase. It said, except for loan 34105, and there's a reason why she wouldn't have been able to do it. Her credit and income wasn't sufficient at the time to refinance. The loan was about $50,000 balance at the time. Jack understood that. It's not something that he talked to her a couple of times about doing, but he understood why she couldn't, and it's why he never pressed that issue, because he understood that she was probably not in a real good position to refinance the $50,000.
They weren't the principals on the loan, they were just the guarantors on the loan.
Gibbons said, what did
Co-makers.
They're I guess they were
All four of them
co-makers.
were on the loan?
Yeah, but it was clearly for the adult daughter. And as I said, Lorain National had the banking relationship with Mr. St. Clair. He'd been a long-time customer of theirs, a commercial customer of theirs, and so they just naturally went to him anytime the loan wasn't paid. So I think Judge Swensky was well within her discretion. She'd already denied their motion to show cause, and this court actually in a prior appeal upheld her decision. This actually has come up twice. The first time, this court decided that the issue regarding reforming the judgment entry hadn't become final. But her order with regard to their contempt against Mr. St. Clair, which she denied as a result of her decision on what she saw in the circumstances here, that was actually appealed to this court, and this court upheld her decision denying their motion against Jack for contempt for not following her order. And then they finalized our motion for relief from judgment, and that's what's actually on appeal. So this court has already once affirmed Judge, it's really the same point. It's the opposite side of the exact same point. If we didn't make our equalization payments, we're in contempt of court. She says, no, we're not in contempt of court because you weren't supposed to pay the Steindl loan. She was supposed to pay it, and when you deducted it from her payment, that was perfectly acceptable. That's what Judge Swensky ruled. That was appealed here. This court affirmed that decision. But then said, but we can't deal with essentially we're asking that the judgment entry be reformed to reflect the real agreement between the parties. And we're proving the real agreement by the course of conduct, by the prior writing that didn't get completely incorporated into the separation agreement, the course of conduct between the parties, and then the fact that she had an opportunity to try and enforce it in April of 2011, chose not to, even though she enforced other provisions of the agreement. And we just say that's proof that she understood what the deal was. Thank you.
And again, Jack, 2 minutes and 45 seconds.
Thank you, Your Honor. There's been a lot of discussion about facts that are not in the record. There was no evidence taken. That was the order of the court that it was going to be an evidentiary hearing only. So what people believed, what people didn't think, none of that is on record. Okay? Nobody testified at the hearing. And as far as the show cause and what the court determined with the show cause, if I remember correctly, the trial court mooted the show cause because of the decision that they had made with regards to this issue, that there was a course of conduct. And that was the first time, or the first or second time around Court of Appeals. There wasn't a final appealable order with regards to this issue, but what the trial court had done was dismissed it as moot because of its findings with regards to the Steindl loan. Bottom line is what the record actually reflects, what was actually submitted to the court, was that Mr. St. Clair comes up with this type agreement in 2014 that he purports is the original agreement, the correct agreement, the agreement that should have been in the divorce decree. It's not dated, it's not signed by anybody. Our client is vehement that she's never seen this before. This was not the agreement that they had worked out. This was not the agreement that they had agreed to. Mr. St. Clair had had plenty of time to file his motion for relief from judgment on the basis of a mistake, which is what he believes it was. didn't. I mean, you say that my client didn't do anything for 5 years. Again, there's no statute of limitations, there's no time restrictions on show cause. There's reasons why people file show causes when they do or when they don't do. But the bottom line is that if you're going to be alleging that there's a mistake in your entry, you want relief from it, you have to do it within a year. Especially if you know that what's in the decree is not what you believe your agreement is. We don't believe that there's any such agreement at all, but if Mr. Sinclair believed that there was some sort of mistake, he was beholden to do something about it long before 2014. So, thank you.
Thank you.
Take care.
All right, thank you for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted to our website and that of the Supreme Court.
Thank you.
Thank you.